best known as 244, Judy Karikeni, who is known as Judy Wetu, and Jenyaga JN. These are the names that Rita gave us. Rita encouraged openness,
cover one issue on behalf of the second, third, and fourth respondents, and then my colleague Mr. Hero will address other issues so that themselves. Before I even submit, I wish to associate myself with the submissions made by the two councils together with the authorities that they intend to rely on as far as they're concerned or applicable to the second, third, and fourth respondents. On my part, I wish to limit my submission on one issue, which I think is critical to this, for the court retires to, consider the issues. More importantly, limit my submissions to the contents of Article 49, sub-Article 1H.
Just give the person the advocates. I see already seated in Maruna. Wacha wakae hapo ndio hapa ikiwe na space. Joto ni mingi hizi mbele. Wakusonge huko nyuma kidogo.
I'm actually okay with that.
No, I don't want you to stand. You might faint. Yes, yes. Any other councils on how his feet? Kisoi.
You know there are no seats.
There are no seats.
Yes. It's council.
No, the other seat. Behind.
They are all standing.
There's no seats in court.
No, they are, but they're standing. They're okay. It's a procedure.
It was not okay. No, I'm not going to and maybe to clear the court, if you are here for judgments and rulings, we are doing this, you can wait. We do this at round 3. Kama umekuja kwa sababu ya judgment and ruling before court number 5, tafadhali hii itachukua muda, turudi saa 9. Unaweza enda mkunywe maji mrudi. Nyabondo si nimekuona, enda. Enda wewe toka huko. Yes, once council is seated, then we'll be good to go. So you take it. Ndio mbaya hapo wewe najua uwezi ona. Ndio hapo. Kisoi kaa hapo nyuma. Murage kaa kisoi huko nyuma. So, Mr. Nyamugo, you can repeat.
Yes.
You are saying that you limit yourself to.
My submissions are limited to the application of Article 49, sub-Article 1H.
Article
49,
Yes.
sub-Article 1H.
Yes.
More importantly, this article provides for the rights of any arrested person. That will cut across from the first to the seventh respondents. It provides that it affords any arrested person the right to be released on reasonable bail or bond terms, pending a charge or a trial, unless there are compelling reasons not to. Police court also should take judicial notice of the term compelling reasons is not defined by the Constitution. So what happens if this term is not defined under the Constitution? It is left to judicial interpretation. I do not want to try and define this judicial interpretation, but compelling reasons, put it simply, means a convincing argument. The work of the applicant today is to put forth a convincing argument that would warrant this court to give them orders as have been sought in the application of the 25th. Our submission, Your Honor, is that there are no compelling reasons or convincing arguments that have been put forth in support of this application. I'll try to assist even the applicants to some of the compelling reasons that are usually advanced by the prosecution for the applicants. So, firstly, there is no evidence that has been put forward by the applicants to show that the respondents have a capacity to influence. If you look at the application that is before you, Your Honor, more particularly, there's these two paragraphs which were referred to you. Paragraph 9 of the supporting affidavit, the applicant states that there is a very high likelihood that the respondents, it doesn't tell us which respondents, it just says that it's a respondent. And you know your own parties are bound by their own feelings. They don't tell us which respondent would likely interfere with this investigation. Our submission is that, save for that paragraph saying that there is a very high likelihood that the respondent will interfere, there is no compelling evidence that has been annexed to that paragraph, say in terms of evidence that can compel this court to grant those orders. It is just a blanket statement that has been put there. The second issue is that the applicant indicates that there is a likelihood that the respondents, more importantly the second, third, and fourth respondents, although it cuts across all the respondents, are a flight risk. The same, there is only a blanket statement that has been made in the application. There is no supporting evidence to back up that blanket statement that has been made in the application. More importantly, the application refers to a respondent. It doesn't say respondents. I refer the court to ground number 8 in support of the application. application and number 9, they refer to the respondent. We don't know which respondent. So I believe in our submission that paragraph does not refer to either the second, third, or fourth respondents. It could be the respondent who's not before this court. If you look at the application, they've indicated that there is one suspect who's still at large. It could be that this respondent referred to is, yes. The third submission that we wish to make is that the seriousness of this offense in itself does not make it a compelling reason to warrant that the respondent not be admitted to, reasonable bond and, bail terms. The assertion that by the prosecution that this is a public interest matter, which assertion is not even in the affidavit or the application itself, also does not make this matter, or it's not a compelling reason in itself to warrant this court to grant the orders or not to grant reasonable bail terms to the respondents. Your Honor, from time to time, Article 49...
That one from taking photos, he's a media personality. He's a guy standing up there with a mask. Kama si wa media, asipige picha. Akuchukua simu mwani. Yes, proceed.
Our humble submission is that, save for these blanket statements which are being made by the applicants, the prosecution, there's no evidence that has been brought forth. I've heard an assertion being made that these are very popular individuals who are likely to interfere with the investigations. Save for that statement, there's no evidence that has been coupled up to support that assertion. It would be even important if at least they would even attach an Instagram account showing that they have so many followers. But I mean, the applicant has, done nothing to, impress upon this court to warrant the grant of such orders. From time to time, Article 49, Article 1H has been abused. That is, as is read together with, that is Section 36 of the CPC. It has been abused by the applicants from time to time. And I think it's high time that we rewrite the judicial precedents around the application of this article. Your Honor, that's my humble submissions on that issue. I'll let my colleague Mr. Zero maybe highlight other issues of the second for response.
Thank you, Your Honor. Your Honor, before I proceed, I would like to pass a message of condolence on behalf of the respondents. We wish to commiserate with the family, friends, colleagues, and relatives of the deceased. Your Honor, number 2, my learned friend for the first respondent has requested me to mention that the media that he meant was not the mainstream media, the one that is on the rumor mongering, but the classical media. So that should go on record that he didn't mean our good friend from the Fourth Estate. Having said that, Your Honor, say that, Your Honor, as a judicial officer, we have noticed in the recent past that it has become customary and maybe...
As a judicial officer, you are saying?
Yes.
You are a judicial officer?
Officer of the court.
Right.
My lady, the brain is starting to become stale as the day ages. It has become customary and to a certain extent fashionable for the prosecution without tying the number to approach the court with miscellaneous applications praying for custodial orders. Your Honor, this honorable court is faced with an opportunity to stop this type of practice that is creeping its head in our courts. Your Honor, you are being called upon to make a determination based on what is called an affidavit. You're being called upon to make a determination based on storytelling. Headline affidavit. You know, there is no evidence that has been annexed onto this document. Big words have been thrown. Some people have been called influential. Another word called flight risk has also been thrown into the document. But, my lady, there is no iota of evidence that is attached to this document. There is a witness who has produced the so-called supporting affidavit. And he has gone ahead to whip this honorable court's emotions by saying they need more time to produce the remaining part of a post-mortem. There is no remaining part of a post-mortem. There is only one document, an autopsy report. That document is conclusive because it is carried out by a registered pathologist. And as they say, Your Honor, medicine is an exact science. That is a document that cannot be controverted by anyone. Your Honor, you have also been treated to another issue of witnesses, and a request has been put to you that they need more time, specifically 21 days, to interview more witnesses in Kikuyu. specific number has been brought to you on the number of witnesses that need to be interviewed. My lady, the census report of 2019 captures the population of Kikuyu as 323,881. 323,881. The prosecution wants to interview all the 323,881. I don't know how feasible that is. Yona, my learned friend, Mr. Ngumbo, has mentioned Article 49(1)H, and I wish to reiterate this, that article confers a right to every arrested person to be released on bond pending trial. And it goes on to say, unless there are compelling reasons. We all appreciate that that right is not absolute, but limited by existing compelling reasons. Yona, if you allow me, I would refer you to the Oxford Law Dictionary, where compelling reasons is defined as powerful, evoking attention, or admiration. The prosecution has not demonstrated any cogent evidence that would convince the court that if admitted to bond, then the second, third, and the fourth accused persons, herein referred to as the respondents, are likely to abscond or involved in acts that would undermine the administration of justice. Yona, you have also been treated to award flight risk, and you have been told that the second, third, and the fourth respondents are flight risks. Yona, the machinery that the prosecution has, and this word has been used severally by prosecution, reduce the risk. You have powers to confiscate the trial documents, Your Honor. And also making an application for the respondents to report to the IO at a time, day, and duration. Your Honor, at paragraph 6 of the said document, the IO speaks to a doctor's report. Which he says that through an X-ray, MRI, which is leaving all of us to assume what that means, the MRI of a deceased that he suffered blunt abdominal trauma and traumatic bladder injury. Then, Your Honor, no report has been annexed to that document. The document that is referred to as the supporting affidavit Your Honor, we are also being treated to given, no gender is given. So we are left again to speculate that there is somebody, a person called a person who is at large. And we are being, Your Honor, you're being convinced that the 21 days they are seeking for, they'll be able to produce the nameless person to record their statement. Your Honor, we need to ask ourselves a question that the deceased, and we have been told that the deceased was a police officer. May his soul rest in peace. The main reason why we are asking this honorable court,
you need to ask ourselves a question.
Yes, my lady.
Yes.
We are coming to the question.
Yes.
You've interfered with my thought process. My lady, the deceased person was a police officer. Now the prosecution is convincing the honorable court that they need 21 days for the accused persons to continue being held in custody. So this is where the question comes in. Being a police officer, with the current emotions that are going on, is the safety of the second, third, and fourth respondent, specifically, and all the respondents generally assured. Your Honor, the court needs to protect the respondents so that we do not face another injury or death. Your Honor, the accused persons, second, third, and fourth, suspects, and more specifically, the fourth respondent is a responsible family man with a young family. In fact, the wife is present in court this afternoon. The fourth respondent has a fixed award which the prosecution has also captured in the document supporting the affidavit. That they arrested him at his house. Therefore, they will not leave the jurisdiction of this court until the case is heard and returned. Your Honor, he is ready. They are ready to report to the IO if need be. And we need to submit also that the fourth respondent is gainfully employed, as a disco jockey, and both the second and the third respondents work with him. Second and third respondents. Your Honor, we also wish to point out that as we approach the Easter holidays, the fourth respondent, through his trade, has executed several contracts to perform and entertain and bring happiness to revelers during the Easter holiday as we celebrate Passover. You know, we appreciate at this juncture that the respondents are facing serious crime of murder, but under Article 49(1)H, the right to bail pending trial, irrespective of the gravity of the offense, they have a constitutional right to be presumed innocent until proven guilty. In conclusion, Your Honor, we will therefore implore this honorable court to admit the accused, the respondents to bail pending trial, and they're ready to submit themselves to any other conditions that the Honorable Court may grant. Lastly, before I yield to my learned friend, we would implore the Honorable Court to give an order for the release of motor vehicle registration number. Yes.
That application now comes.
Yona, that motor vehicle has not been captured in this document. It is not part of the investigation. If it was, Your Honor.
Let's address me on the issue of the accused persons, or rather the suspect being remanded.
I stand guided, Your Honor.
Yes. You can make the issue, you can make a formal application to address the court on the issue, which has not been mentioned.
It has not been mentioned in this document. Yes, Your Honor, as my learned counsel have submitted before me, we wish to request this honorable court to grant the prayers that we have submitted on. Unless the honorable court has any questions for me, we wish to yield to my reply. Thank you, Your Honor.
Is another counsel submitting on behalf of the second, third, and fourth?
No, I think.
We're done with second, third, and fourth?
Yes.
Suspects. Then we go to fifth and sixth and seventh respondents.
Thank you very much, Your Honor. Your Honor, the fifth, sixth, and seventh respondents. Relevant to this application, I will start with the role that the fifth respondent is alleged to have played.
Yes.
The fifth respondent, that is Khadija Abdiwako, on the night of the alleged incident, which is the 16th of this month, had been assigned as the duty officer at Kikuyu Police Station to respond to traffic incidents on the night of the 16th. Your Honor, relevant to this application is that on that 16th, the wee hours of 16th of March, a report was made to the police station by a member of the public that there has been a non-injury incident involving two motor vehicles. Khadija, the fifth respondent, walked with the reportee to the scene of the incident. The incident happened outside the police station. And this is relevant, and I'll revert to it as I conclude my remarks. So, when the police officer Khadija visited the scene, she found an apparently intoxicated person, identity not known, but very intoxicated, and two motor vehicles. And the other respondents, the first to the fourth. There was an attempt by the deceased to be aggressive at one of the respondents, and at that point, Khadija, the police officer, the lady you're seeing here, intervened to restrain the deceased officer. At that point in time, the identity is not known. So he's just a member of the public, but you cannot.
No, you're not giving evidence.
No, this is important, Your Honor.
Yes.
This is important.
You
So
said that she attempted.
she restrained. So the deceased was aggressive at some of the respondents, and Khadija intervened. This is the police officer. Khadija is the fifth respondent. Intervened to restrain that altercation.
At that point in time, there was no fight, there was nothing that was happening. Just a traffic incident where some two motor vehicles had been involved. The fifth respondent, Your Honor, accompanied the deceased to the police station, and one of the respondents, so that a statement can be recorded as to that non-injury incident. She left the deceased in the police station shortly to have the vehicles towed. Remember, this incident is outside Kikuyu police station. On coming back, it turned out that the deceased officer was unwell. Requested, Your Honor, this is important. So the deceased police officer, on coming back, the deceased, again, not yet known whether she is even a CID officer, said he's unwell, he would like to be shown the bathrooms, was shown the bathroom, took a bit of time in the bathroom. They were concerned, they went to check, and this is now the people who went to check are the gentlemen, the 6th and the 7th. And they found a person who appeared unwell. So they very quickly, as responsible citizens, felt, not even record the statement, this person needs treatment. Your Honor, a lady who was sleeping behind the car of the deceased came to the police station. I have to finish because you brought this application in the morning. You did not serve us. You did not have the opportunity to put in a replying affidavit. Matters that are material. Please. Yes. Yes, but please. Yes. Yeah, let me proceed. Thank you, Your Honor. So, a lady who was in the company of the deceased police officer came and said, sorry, in the company of the deceased, because the identity is not yet known, said, I'll call someone, you don't even need to take him to hospital, I'll call someone.